24A03697, Renard Nelson versus Trisha Wilson. And Mr. Livnut, I think this is your motion.
Yes, Your Honor. Your Honor, defendant Trisha Wilson, appears before you today in a very straightforward motion for attorney's fees as a result of the litigation brought on by the plaintiff. As you know, the statutes 9-15-14 or 14-15 B&A exist to prevent abusive litigation, and it's hard to describe the litigation in this case as anything less than abusive. To put it simply, not only was this litigation brought on for purposes that were clear from the outset, as if you've seen the exhibits that were filed, the litigation occurred right after the plaintiff expressed his extreme dissatisfaction with the court-ordered child support, which he continues to refer to as alimony. And then after that text that email, that communication came forward this lawsuit, which was completely and ultimately baseless, and then subsequently dismissed with prejudice after a motion for summary judgment was filed. Under A 9-15-14A, the abusive litigation fees are appropriate where litigation is just baseless from the outset. There's no justiciable issue. And in this case, the issue, although it may appear at first that there is a real issue, the facts make it clear that plaintiff lacked any basis for believing that this particular defendant was at fault for his injuries, so to speak, and he never made any effort to clarify that because it didn't matter, which leads into Part B of the statute, which has to do with litigation being brought on for harassment purposes, that this litigation was designed simply just to harass defendant Trisha Wilson. And when that reached the end of its rope, plaintiff dismissed, and we brought this motion forward.
Mr. Nelson, do you have anything you'd like to add?
Yes, good morning, Your Honor. So my position is a complete misrepresentation of the facts of this case. And although I applaud the attorney for trying to frame a great argument out of nothing, the point is I am an injured party. My ex-wife has an incurable transmitted disease, sexually transmitted disease, that she passed on to me. I am the injured party. My suit was not based on harassment. My suit was based on I am now living with something because of her negligence forever. The only reason, and this court previously dismissed this case with prejudice based off of counsel, which you just heard from, his particular motion. At that time, he did not ask this court for attorney's fees.
All right. Is there anything
Okay,
else?
No. I had to erase a call that was coming in. So, hello? So
I can hear it.
okay, so here's my position. First of all, I brought the lawsuit because it's a real thing, not because I'm trying to harass. I have no win in harassing the mother of my children in any way. The only reason that suit is not in front of you today is because it's not the best thing for our child for us to continue litigations. We need to start healing. The next thing I would like the court to realize is my ex-wife, has a personal wealth of over $2 million. I do not. I am no way wealthy. And she spends money like water. These legal fees are a drop in the bucket to her. And if anybody is being harassed, it's me. You cannot say that because you hit my car, I have to pay your attorney's fees. I'm the injured party. The only reason, again, that this is not in front of you anymore is because we need to start healing as a family. This has nothing to do with courts. This has nothing to do with lawyers. We as a family need to start healing for the betterment of our child. The last thing I would say is this court has dismissed this case with prejudice based off Mr. Livnat's motion to the court, which he coerced me into sending to the court with the term with prejudice in it. But the prejudice, the with prejudice has nothing to do with this case having no merit. That's his wording. This is all about we need to start healing. And second, she does not need her attorney fees replaced. She has a personal wealth well over $1 million, near $2 million. And this, if anybody's being harassed, it's me. And I also would like the court to look at that this case has been dismissed. So us being here at this hearing today means the court reopened something that was already final just because I guess her attorney asked or whatever. But I also would object that we're even having a hearing on a case that has already previously been dismissed.
All right, Mr. Levnat, is there anything else that you'd like to add?
Your Honor, I just want to correct the record. Although you might be aware that plaintiff had sent an email to myself and to, I believe, your staff attorney or clerk requesting for the case to be dismissed. Your clerk replied an email to all counsel and indicated and suggested that I might assist him in drafting that motion. I offered him to do that. He accepted. I sent him that motion and was very clear in that email that that I'm not his attorney and that he needs to verify that independently, and he should still get an attorney and look over it. He filed it, and that's how we got here today. There was no coercion. There was nothing improper there at all. Simply complying to try and expedite the process at the suggestion of the court, Your Honor. As for the other allegations that were made, the only thing that Your Honor, I trust that you've read the pleadings, you've read the exhibits here. It's just textbook abusive litigation designed to harass Miss Wilson, and it's the kind of litigation that the statute was designed to prevent. And for that reason, she is seeking here the fees that she had to spend to litigate. And with that, Your Honor, I have nothing else to add.
All right, I am going to look at all the cases that or all the exhibits and the.
Matt,
Hold on one second, Mr. Nelson. I will look at all of the exhibits on the record, and I will issue an order in this case, okay?
Thank you, Your
Mr.
Honor.
Nelson, I've heard everything I need to hear from the parties, okay?
Thank you, Your Honor.
All right, y'all are free to go.
Mr. Nelson, I'm sorry, excuse me. Mr. Nelson, if you would please leave me your phone number and email in the chat before you leave.
okay, in the chat.
Yes, thank you.
Thank you.